Subcommittee on the Constitution, Civil Rights, and Human Rights will come to order. Today's hearing is entitled Stand Your Ground Laws, Civil Rights and Public Safety Implications of the Expanded Use of Deadly Force. We have a large audience in the room today. At the outset, I want to note that the Senate rules prohibit any signs of approbation or disapprobation, which would include outbursts, clapping, or demonstrations. If there's someone who wishes to be witness to this hearing and can't attend it in this room, there is another room available, room 226 in the Dirksen building. I'll begin by providing opening remarks and then give my ranking member, Senator Cruz, an opportunity before we turn to our witnesses. The debate over Stand Your Ground laws raises fundamental questions about self-defense in the United States of America. In recent years, we've seen a dramatic increase in laws expanding the situation in which a person can legally use deadly force in response to a perceived threat. Florida passed the first of this new wave of Stand Your Ground laws in 2005. Prior to 2005, Florida law held that a person outside his home could not use deadly force and then claim self-defense if the person could have safely avoided the confrontation. This, quote, duty of safe retreat, close quote, sought to prevent public disputes from escalating into violence. But the gun lobby pushed to change Florida's law so people could shoot someone who threatened them without first trying to avoid a confrontation. Florida wasn't the first state to adopt this Stand Your Ground principle, but Florida's 2005 law expanded the principle in several dramatic new ways. First, the law grants criminal and civil immunity for uses of deadly force in Stand Your Ground situations. Second, it replaces a defendant's burden of proving reasonableness with a presumption of reasonableness when the defendant shoots anyone who intrudes upon his home, porch, or vehicle. Third, it even allows the use of deadly force when a threat is not imminent. The gun lobby wanted to spread Florida's law across the nation. So the National Rifle Association went to ALEC, the American Legislative Exchange Council, and asked for their help. Now, ALEC is an organization that brings corporate lobbyists and state legislators together for conferences. They draft model bills, and then they work to get them enacted. In 2005, ALEC adopted model legislation that was nearly identical to Florida's law. They then began promoting it in state houses across the country. Within a year, 13 more states passed similar laws. Today, 25 states, not counting Florida, have passed a law based in whole or in part on the ALEC model. ALEC called the enactment of these laws one of, quote, ALEC's successes, close quote. CNN described ALEC as being, quote, behind the spread of Stand Your Ground laws, close quote. The Wall Street Journal said ALEC was, quote, a key advocate for them. Now that ALEC-style Stand Your Ground laws are in effect for over half of the United States, we're seeing their national impact when it comes to public safety and civil rights. This is what we will learn from our witnesses today. These Stand Your Ground laws have led to increases in homicides and firearm injuries, including 600 additional homicides per year, with no deterrent effect on crimes like robbery or assault. This point was made in several studies, including recent research from Texas A&M University. Second, these Stand Your Ground laws have allowed shooters to walk free in shocking situations. Shootouts between rival drug gangs, drug deals gone bad, and more. This point will be made effectively by the testimony of David Laban, President and CEO of the Association of Prosecuting Attorneys. Third, in some devastating cases, the laws have emboldened those who carry guns to initiate confrontations which have ended up killing unarmed children. The testimonies of Sabrina Fulton and Lucy McBath about the devastating losses of their sons make that point more effectively than I ever could. Finally, these stand your ground laws increase racial disparity in our criminal justice system. One study found that in stand your ground states, nearly 17% of homicides involving white shooters and black victims were ruled justified, compared to 1% of homicides with black shooters and white victims. At my request, the Congressional Research Service analyzed FBI data on justifiable homicide before and after the 2005 wave of stand your ground laws, and found that racial disparities clearly increased. I'll be putting the CRS memo in the record. It is clearly time for stand your ground laws to be carefully reviewed and reconsidered. Whatever the motivation behind them, it's clear these laws often go too far in encouraging confrontations that escalate into deadly violence. They are resulting in unnecessary tragedies, and they are diminishing accountability under our justice system. I'm pleased that the efforts to reconsider these laws are now underway. Earlier this month, one of the legislators who drafted Florida's law joined with some of its chief opponents in a bipartisan effort to change the law. They've been passed in a state Senate committee in Florida. There's more that needs to be done, but we seem to be moving past the question of whether stand your ground laws should be fixed. Now we should be looking at the best way to fix them. I urge other states that have stand your ground laws to revisit them as well. To the extent that stand your ground laws were passed based on the ALEC model, I would note that few who are connected with ALEC appear wedded to that model today. I reached out to every company and organization that has been publicly listed as a member or sponsor of ALEC since 2005, simply asking them, do you support the Stand Your Ground bill? 140 of them responded. Only one said yes. Even ALEC, through a Connecticut state representative and its chairman, Mr. Piscopo, made a statement to the press that ALEC no longer has a policy on stand your ground laws. It is also important that Congress review stand your ground law because of the way proposed federal legislation implicates those laws. Just this past April, 57 senators voted for a gun lobby amendment that would allow a person who receives a concealed carry permit in one state to carry his gun in every state, even if the person would be disqualified from getting a permit in the other states because of criminal convictions, inadequate training, or other factors. Congress should think carefully about how proposals like this would mix with stand your ground laws. Today we have before us a distinguished lineup of witnesses who will talk about the impact of stand your ground laws on public safety, civil rights, and American families, and ways that we should work to fix them. I look forward to their testimony, and I now recognize the ranking Republican member, Senator Cruz.
Thank you, Mr. Chairman. Thank you to the witnesses who have come here this morning. Thank you for everyone who has come to join this hearing on a very important topic. I'd like to talk about three different issues concerning stand your ground legislation. The first is the difference between serious efforts to stop violent crime and efforts to advance a political agenda. I've spent much of my adult life working in law enforcement and emphatically agree that law enforcement should be vigorous, going after violent crime, protecting the innocent, protecting those who are preyed upon by violent criminals. Indeed, one of my most significant criticisms of this administration's enforcement of justice is that they have not made prosecuting gun crimes a priority. In 2010, over 48,000 fugitives, felons, and other prohibited purchasers attempted to illegally purchase a firearm. And yet, out of over 48,000, this administration prosecuted only 44 of them. In my view, that is utterly indefensible. If you have felons and fugitives attempting to purchase illegal firearms, we should be going after, investigating, and prosecuting each of those cases. Let me reiterate, out of over 48,000, this Justice Department prosecuted only 44. Likewise, the prosecution of violent gun crimes has dropped significantly from a high of over 11,000 in 2004 to a low in 2012 of 7,774, which is a 29% decline. If we were to put action to all of the rhetoric given about stopping violent crime, we would again put priorities to prosecuting those who commit crimes with guns. Unfortunately, there are many in Washington who seem more driven by advancing a political agenda than actually putting in place common sense steps to stop violent crime. And that leads to the second point I want to make, which is that in our federalist system, criminal law is primarily given to the states to enforce, and state self-defense law is not, in our constitutional system, the responsibility of the federal government. The federal government doesn't have the jurisdiction, doesn't have the constitutional authority to determine what the substantive criminal law should be in each of our 50 states, and indeed it is quite fitting with the Founders' design that each of those 50 states would make different judgments, different decisions based on the values and mores of their citizens. And so that does raise the question as to the purpose of this hearing. If it is not within Congress's jurisdiction to legislate substantive state criminal law, it raises whether there may perhaps be a broader political agenda behind the hearing instead. The third point I would make is that self-defense is a bedrock liberty of every American. And I would note, this is not a new concept. Indeed, the U.S. Supreme Court in District of Columbia versus Heller stated, the inherent right of self-defense has been central to the Second Amendment right. Now, some who get their news from the modern news media may believe that was a new creation of the modern court. I would note that that idea has been around from the founding of this nation. Indeed, Justice Harlan, for a unanimous Supreme Court in 1895, stated the following, quote, "He was not obliged to retreat, nor to consider whether he could safely retreat, but was entitled to stand his ground and meet any attack on him with a deadly weapon in such a way and with such force as, under all the circumstances, he at the moment honestly believed and had reasonable grounds to believe was necessary to save his own life or to protect himself from great bodily injury." The Declaration of Independence begins with the right of life, liberty, and the pursuit of happiness given by our Creator to each of us. And if an individual is confronted by a violent aggressor, the right of self-defense is an inherent right in each of us. And the notion that critics of these laws put forth, that if you're attacked on the street by a violent attacker, you're obliged to turn and run rather than to defend yourself, is a notion that is contrary to hundreds of years of our jurisprudence and to the rights that protect all of us. I would note also that the chairman suggested a racial disparity. Look, the problem of violent crime in this country is enormous, and tragically, minority communities bear much of the cost of violent crime. Minorities find themselves at times aggressors, but often victims of violent crime. And I would note, in Florida, the data show that African American defendants have availed themselves of the stand your ground defense more frequently than have Anglo defendants. According to press reports, 55% of African American defendants have successfully invoked the stand your ground defense in prosecutions, compared to a 53% rate in the Anglo population. This is not about politicking. This is not about inflaming racial tensions, although some might try to use it to do that. This is about the right of everyone to protect themselves, to protect their family, and I will tell you, given a choice in a confrontation between a violent aggressor attacking an innocent civilian, I, for one, will always, always, always stand with the innocent civilian. Now, we have a system of justice to determine if that is the facts in any particular circumstance, but notably, the stand your ground defense only applies when it is a violent aggressor attacking an innocent defender. If it is not, the defense doesn't apply. So this is a rule that only applies to protect innocent victims from violent aggressors, and I find the notion that we say if you and your family are attacked on the public street, you don't have the right to defend yourself. I find that an astonishing proposition, and one that I certainly hope members of the U.S. Senate will not advocate.